What a lessor needs to take cognizance of is that granting a lease of over 21 years actually entitles someone to get a title, because under the Land Act, a lease of over 21 years actually grants you a title. So you always want to either give a lease of 20 or 19 years if you do indeed want to take a long-term lease. My name is Divinah Ongaki. I'm a lawyer here in Kenya. I've been practicing for 7 years across various practice areas, including real estate, corporate commercial transactions, litigation, succession matters, among others. I'm a partner with Agema Analysts. It's a cross-border legal services firm. This means we are based in various jurisdictions and we offer legal services in those jurisdictions. We have offices here in Kenya, in Nairobi and Mombasa. We have offices in Cairo, Dubai, as well as Hamburg in Germany. A lease is a grant of exclusive possession in respect of a property. What that means is by granting someone a lease, you're creating a separate estate. If you're a landlord, you are giving that person rights that are subservient to your estate. This means you can't just walk in to their property because your interest and their interest, they're running concurrently. Even evicting that person, there are special mechanisms and procedures in law for actually removing them. You can't just walk into their property at any point, because at the point you've registered or created a lease, essentially that person has certain rights within the term of that lease. Legally, the essentials for the lease are that it has to be in respect of a particular property, it has to be for a defined term, and of course it has to grant exclusive possession of the property to the leasee. The core difference between a lease and a license is that a lease is a registrable interest. A license is more of a contract that gives a person certain rights to access the property, to use it in a particular way, but it's not an exclusive grant of possession in the same way a lease is. You would not be able to produce a license to a land registry for registration, whereas a lease is actually a recognized instrument for registration. The main parties, of course, are the lessor and the leasee in a lease. A lessor's role is, of course, granting the exclusive possession to the tenant. Now, at the point you've created that lease, you have to give the tenant something that is legally defined as quiet possession. That means you can't just walk into their premises at odd hours demanding maybe access or to see something, because essentially it's the leasee's domain. So you have to ask for permission before you enter the property. The other obligations of a landlord would be maintenance of the structures. Let's say there's a building and you've granted only a section of it. So maintaining the roof and the outside structure, that is your responsibility. The leasee's only responsibility is to maintain the premises that you have leased to them. So if it's a shop within a premises, only that shop is their duty. The rest, the outside, the exterior walls, the roofs, that's your responsibility to maintain. The lessor also pays the rates on the land and the rents on the ground rents on the land. The leasee's role is primarily to pay the rent and the service charge. Now, of course, now leases have become features of contracts. Initially, they were meant to grant the estates, the land itself. But as society progresses, leases are becoming features of contract, in that a lot of contractual terms are inserted in leases and they have to be negotiated. So like the obligation not to commit waste, the obligation not to commit a nuisance on the property, and also the leasee's obligations to other lessees on the property and how the lessee behaves within his premises. For lessees, it's important to, of course, undertake some due diligence over the property to ascertain that the person who's actually granting you the lease is the proper owner and has the right to actually create that lease. You should also see if there are supervening interests on that title. What this means is if there's a charge on the property, then ideally you would need the bank's or the lender's consent to even enter into a lease of that nature. A leasee should also assess the size or the area of the premises. There are instances where rents are based on the actual square footage, so it's important to undertake an assessment of the floor area if indeed your rents are tied to the square footage or floor area. The other thing I think that is important for leases to take note of is the condition of the property at the point they're entering. A lot of lease disputes center around when the leasee wants to leave and they're being told to return the premises to the state it was given to them. But if there's no actual record of how the premises was when they were entering, it then becomes sort of push and pull as to how to restore it to the state it was in. So these are just some of the things a leasee should have at the back of their mind. They should also consider issues to do with the user. So when you're leasing a property, you want to either run a particular business on it. If it's a go down, you want to lease it for storage of something. So you should check the land on which you want to be granted a lease. It actually accommodates the user that you want. The types of leases, generally, there are short-term and long-term leases. Short-term leases can be anything from 1 year to 5 years. Leases of below 2 years, they're not registrable interests. Leases of 5 years and over, they can be registered. Of course, they are terminated by way of a surrender when the party wants to leave. So a surrender has to be registered on the title to bring the lease to a close. Long-term leases can be for over 20 years or even 99 years. Now, what a lessor needs to take cognizance of is that granting a lease of over 21 years actually entitles someone to get a title, because under the Land Act, a lease of over 21 years actually grants you a title. So you always want to either give a lease of 20 or 19 years if you do indeed want to take a long-term lease. Controlled tenancies are a feature of a legislation called the Landlord and Tenant Hotels, Shops and Catering Establishments Act. Now, the act is quite archaic, meaning it's been with us since independence. There are some that are calling for an overhaul of that legislation since it's not responsive to the current needs of the market, of the leasing market. Controlled tenancy is a tenancy that's created under a legislation called the Landlord and Tenants Shops, Hotels and Catering Establishments Act. Now, it's quite an archaic statute, and there's been calls for it to be overhauled. There's actually a bill that has been floated, and I believe it's currently in debate with the Senate. What the Landlord Tenants Shops, Hotels and Catering Establishment Act provides is that where a tenancy is not in writing, or where it is in writing, it's not for a period of over 5 years, or if it is for a period of over 5 years, it has a break clause or a termination clause, then that is a controlled tenancy. Now, a controlled tenancy is not optimal for a landlord because that piece of legislation is designed to protect tenants. It leans heavily in favor of tenants. So examples I would give is that it doesn't allow the landlord to terminate the tenancy easily. You can't have rent assessments within the period of the tenancy without, let's say, reference to the tribunal. This is the rent tribunal. There are also only certain specified grounds on which you can terminate it, and they're listed under the Act. So if you're not relying on those particular grounds, you can't actually terminate the tenant. And it's very hard to actually evict a tenant when they are a controlled tenancy. So sometimes landlords find themselves in situations where a landlord is there, you can't increase the rent, you can't vary the rent because they'll rush to the rent tribunal. or you can't terminate the lease even if you have someone who wants to pay more for you, because there are certain procedures that have to be followed. So we always advise landlords, especially of commercial premises, because the Landlord and Tenant Shops, Catering Establishments and Hotels Act actually applies to commercial premises. So we usually advise landlords to have leases that are 5 years, over 5 years. Yeah, so it can be 5 years, 1 month, can be 5 years, 3 months. So not all leases are registrable. As I said, leases that are under 2 years are not registrable. Yeah, so leases of 2 years and over, then that's when the registration applies. The procedure for registering a lease is that first, the lease has to be, of course, negotiated. Once you've reduced it in writing and both parties have executed in accordance with the law, it's taken for assessment of stamp duty. Stamp duty on leases is usually 2% of the highest annual rent. So once it's stamped, it's then forwarded to lands for the registrar to actually note it on the title. Not all leases are registrable. As I said, leases that are under 2 years are not registrable. Yeah, so leases of 2 years and over, then that's when the registration applies. There are consequences for not registering a lease. We find certain instances where parties are trying to either A, save on stamp duty, or B, do not understand the significance of registration, so they opt out. What they need to know is that not registering a lease, it reduces it to a contract inter parties. So the effect of registration is that it gives third-party effectiveness. What that means is anyone who is dealing with that property can go and do a search and actually see that your interest is noted there. So if you don't register it, no one will know. If someone else comes and registers another interest, it supersedes your lease and it could be actually detrimental to you. Let's say a good example I can give would be a bank loan. So if you have taken a lease, you've not registered it, and the bank comes and takes a charge over the property without knowledge of that lease, or even where you do the lease after the charge is actually created, that charge takes precedence. Yeah, so registration gives effect to most of the interests in land. Not registering it reduces it to a mere contract, and enforceability of that might actually not be as effective as when you had registered a lease.